Court, Counsel. My name is Sam Hansen. With me at Council table is Dan Bellig. Together we represent the 17 parents and 25 children who are the plaintiffs in this action. This appeal involves the interplay between two statutes, the older newborn screening statute and the newer 2006 Genetic Privacy Act. The critical issue here is whether the newborn screening statute expressly authorizes the Department of Health to do what would otherwise be prohibited by the Genetic Privacy Act. And we would ask this Court to rule that it does not, and in fact adopt this rule of law, that although the Newborn Screening Act expressly authorizes the collection of blood samples to screen for genetic disorders and the retention of positive test results, it does not expressly authorize the continued storage, use, or dissemination of blood samples or negative test results after the initial screening. Therefore, this latter activity does not fall within an exception to the Genetic Privacy Act, and in fact is prohibited by it. And in that way, the two statutes are reconciled. We ask the Court to remand this case to the District Court, both to direct that it enter an injunction that the blood samples and the negative test results be destroyed unless informed consent is obtained as required by the Genetic Privacy Act, and that it remand for trial the issue of damages, which would be reinstated by that conclusion, on damages under Section 1308 and the tort claims and the constitutional law claims.
Counsel, can you help me understand I understand the argument being made about waiver, but if we get to the question about whether this is genetic information, help me understand your statutory argument about how these blood samples are genetic information.
Yes, Your Honor. As you've indicated, we have suggested that's not a preserved issue. I understand it's always difficult to interpret a statute if a predicate to the statute is not before you. And so we have argued that on the merits. If reviewed, we think that the administrative law judge in the Court of Appeals came to the right conclusion, that the common meaning of the word information as genetic information under Webster's dictionary talks about knowledge obtained from investigation and study, and actually uses as an example the sequences of DNA. These blood samples, obviously I don't think there's any claim that the test report would not qualify, but these blood samples are documents that contain the DNA of each of these 800,000 children.
For your argument to prevail, do we have to conclude that the samples themselves, as opposed to the results from the samples, but do we have to conclude that the samples themselves are genetic information?
There are two separate issues, Your Honor, and we would still contend that the test results are subject to the Genetic Privacy Act, even if the samples were not. But because the samples contain the DNA information, and the test results, at least as reported to us by the Department thus far, have not identified DNA, the more crucial of the two are the blood samples.
Counsel, let me ask you a question to follow up on the Chief Justice, which is the earlier part of that same statute delineates between genetic information and specimens. And one would think that possibly that particular distinction would carry through to the second part of the statute. So why are the blood samples not specimens rather than genetic information?
Well, they are specimens, Your Honor, I think under that first definition, but there is no carry-through in that definition to the second, because the second says genetic information is also, and creates an independent and separate and freestanding, I think, definition. So I don't believe grammatically that you would read the first section to bleed into the second.
Counsel, now I really got to focus in here, is what Justice Strauss is saying. It appears to me that you're not arguing the falling under the definition of subdivision A, but you're really focusing on subdivision B. Is that correct?
That's correct, Your Honor.
But these are two subdivisions of the same statute. Is that correct?
They are.
Now, both the A and B use the term biological information. And A uses the disjunctive or, individual's biological information or specimen. You've conceded that a blood sample is a specimen. What is the distinction? You've got to tell me very clearly what makes B so different that we can't, and we don't look at the wording of the legislature in A1, where there's that disjunctive or and a separation between biological information and specimen, and you said a blood sample is a specimen.
Your Honor, I think these are two separate definitions. They're not combined.
Well, but
they're independent of each other.
B has an also. It's an also. It seems to be supplemental. I'll give you time to tell me. You obviously are feeling that. You're getting a feeling is that statutory interpretation. I'm having a hard time reading them separately. So I better give you a chance.
Yeah, I understand, and it's a new thought to me because it hasn't been argued in that form. The argument was we didn't fit under A, and we have not contended that we fit under A because that seems to be looking at test results, not at the specimen itself. B, I think, enlarges upon the definition. It is an independent alternative definition of genetic information, and it doesn't have the narrow confines that it be the results of an investigation. It doesn't have the narrow term of specimen. It talks more broadly about genetic information. Information is defined as knowledge and facts, including DNA.
May I pause here a little bit? It refers to it uses the term biological information, but it refers to a genetic condition. I mean, genetic information is used in both statutes, so I'm not seeing a distinction. I'm saying that one refers to genetic information, the other does not. There's a reference to a genetic condition. I mean,
no, my point was that the second subdivision B uses the term biological information, whereas A is more restrictive and refers only to biological specimens.
Counsel,
biological information is broader.
With respect again to the Part B, how can a blood sample be something that is or might be used to provide medical care to an individual?
It is in the very newborn screening process, Your Honor. The blood sample is the basis for the testing to determine whether congenital disorders exist, which is a form of medical treatment.
But I guess maybe I'm being more precise than you are in drawing a distinction between the sample and the analysis that comes from the results of the analysis. And it seems to me the blood sample is something different than providing the analysis, and then that analysis is then used, as you say, to provide some type of care. But the blood sample itself, it seems to be...
You couldn't do the analysis without the blood sample. Therefore, you couldn't render the medical treatment without the blood sample.
So do you then say that we should interpret the statute to look at the blood sample and the analysis derived as one and the same under the definition of genetic information?
In the sense that both are biological information, or at least the blood sample it is.
It seems to me that interpretation would be inconsistent with A, and that's why I'm pressing you on that.
Well, that gets back to the question whether these are dependent definitions or independent. And our view is that they're independent, and that's why the word also is used in Section B to separate these two.
On this question that Justice Dietzen is asking you about whether the blood samples themselves fall within the definition of paragraph B,
yes.
I'm wondering if you think there's any relevance to the fact that the legislature used the word collected. It says collected from. I mean, you collect a blood sample from a person.
Correct.
You don't collect a test result from a person.
Right. I think that would reinforce, again, this idea that these are independent definitions. And it would seem, just backing up a little bit from focusing on these words, would it be the legislature's intent to protect the document that refers to a test result, but not the critical document that has the DNA contained within it? Does that have any rationality to it whatsoever? It seems to me not. If the intention of this act is to protect genetic privacy, DNA being the blueprint of each one of us, our most intimate private information that could exist, then why would they draw the line between the test result that interprets the blood sample is private, but no, the blood sample itself is available as public information. That makes no sense whatsoever. And I think interpreting them as independent definitions, and as Chief Justice Gilday points out, the word collection helps that definition to show this is something different. This is talking about biological information that should be treated differently than the definition contained under A.
Counsel, I hate to press you on this because, as you said, that doesn't appear that it's been argued in quite this way, but Subdivision A1 talks about the individual's biological information or specimen, which could at least lead to a reasonable conclusion that biological information or specimen are separate. If it is in fact a specimen for purposes of Subdivision A, then it means that, at least the way I look at it, that you need to have a different definition of the exact same term, biological information, in subsection A as in subsection B, or else I don't know how to get to your interpretation. Maybe I'm wrong about that.
I don't think it's only a specimen. I was asked, does it constitute a specimen? I would say yes. In fact, under the rules, the Department of Health is required to produce the form on which the specimen would be taken, so it does satisfy that, but that's not an exclusive term, it doesn't seem to me. Well, that doesn't make it not biological information.
And again, A refers overtly to analysis.
It does.
I mean, A is about analysis, B is about collection.
And that's exactly why we don't rely on A, because it has that qualification. It looks to the test results, requiring an intermediate step, taking the sample and doing something with it, whereas B enlarges the definition to include, we think, the sample itself. Now, let me go back to these two statutes for a minute, assuming that...
Can I just ask a background question? Under the infant testing statute, is the only testing carried out pursuant to that statute blood tests? I mean, because it provides more broadly for, it doesn't say blood tests. It says tests for heritable and congenital disorders. But is that blood tests the only test carried out?
I think they are, Your Honor. I think you have to read that statute in connection with then the authority given by the statute for the commissioner to prescribe rules for conducting the testing. If you look then at the rules, the 4615.0550B says the responsible party shall collect the specimen for screening and then send it to the Department of Health laboratory. So as I read the rules, as far as I'm aware, the only testing that is done is blood testing. And I think you get express authority to do that by the combination of the statute, the delegation to the commissioner, and then the rules that prescribe how the testing shall be done that have been adopted by the commissioner. If I could go back to these two statutes, I want to make this point clear. The Department of Health actually violated both statutes, not just the Genetic Privacy Act, because even before the Genetic Privacy Act was adopted, the newborn screening statute limited the authority of the department to do newborn screening, a set of tests that were prescribed, now some 50 or 51 of them, and to retain only the positive test results. That's what the statute provides. When in 1997 the department began to collect all blood samples and keep them, and began to keep all negative test results in addition to the positive, they exceeded their authority. They violated that statute, and they didn't do it in a small way. These have accumulated to 800,000 blood samples in 2008. At $70,000 a year, that's another 150,000 currently. and over 1.5 million of these test results. And the most egregious conduct and excessive authority, it seems to me, is then the dissemination of up to 50,000 of those to be used for non-newborn screening research. Clearly nowhere authorized in the statute. So even before the Genetic Privacy Act was adopted, these plaintiffs would have a cause of action for an injunction against the Department of Health for exceeding their authority under the Newborn Screening Act, because clearly this practice has been ultra vires. But then it's all made all the more clear by the Genetic Privacy Act adopted in 2006, and specifically using the term that we are going to preserve other laws, but only those other laws that expressly address this topic. And that word, I think, is used very advisedly. You would more commonly see in statutes a phrase, as otherwise provided by law. If that phrase were used here in the Genetic Privacy Act, I think you could look at the newborn screening statute with a much broader view. You could look for what the express authority was to the department, but you could also look for what might be necessarily implied. That would be your normal standard of construction. But the legislature chose the term expressly to limit that construction. In other words, they were going to only preserve and leave operative the laws that expressly addressed this issue of genetic privacy and provided an alternative way of doing it. And the newborn screening statute does, but it only does to the extent of allowing the initial screening to be done, because that is expressly authorized, and allowing the retention of the positive test results. Outside of that, there is no express authority. Now, we claim the word express is not ambiguous. We think it's a clear term. It means directly, clearly stated. It's the opposite of implied. It excludes implied. And if you look at the section primarily relied upon by the Court of Appeals under the Newborn Screening Act, Section 144.125, Subdivision 3, this is the section that says the responsible party shall advise the parent that the department may retain their samples. That is the classical indirection. It doesn't, a direct express statement of authority would say the Department of Health is authorized to retain the samples. This says it only indirectly. Perhaps if you were allowed to construe the whole statute, you would say that implies the authority to retain, not to use, not to perform other tests, not to use for research, but maybe to retain. But the legislature didn't ask you to construe it in that way. They said construe it for what is expressly provided, and that clearly is not expressly provided.
Counsel, explain to me how your rule plays out on the ground with respect to the newborn statute, and there's something kind of lurking over the shoulder here as a federal regulation about retention for 24 hours. But as I understand, 24 months, excuse me, is that my understanding is that what's expressly authorized is the collection, the testing, and then only the storage of the positive results.
Right.
So what is the department to do then? Once the testing is done and there's no positive result, is it to destroy the specimen immediately? How does that interact with the federal regulation? What happens here with your rule? I mean, is it, because I think we're dealing in the real world here, we need to see how it plays out.
As I understand, Your Honor, the federal regulation, it only applies to test results, not to the blood samples. So I don't think there's any issue about that. My understanding also is that prior to 1997, the department did destroy the blood samples after the initial screening was completed. I don't know that they did it immediately. Perhaps you'd allow some reasonable period of time in the event there could be questions about testing, et cetera. But if the test results were negative, they would eventually, and not as long as 2 years, but eventually they would destroy those samples. In 1997, they made an administrative decision without any change in the statute, without any rulemaking to authorize it, to keep all of those blood samples. It became, of course, an enormous resource now probably close to 1 million blood samples which have commercial value. But they didn't go to the legislature to ask for authority to do that. They attempted to achieve it by rulemaking, but then they ran into the Genetic Privacy Act, and the ALJ said you can't adopt this rule. You can't be given that broad authority because it conflicts with the Genetic Privacy Act. You're asking to do things without consent of parents where the Genetic Privacy Act requires informed consent. So they were unable to do it that way. They went to the legislature to try to get exempted from the Genetic Privacy Act, still continuing to store all these samples, not changing their practice, and they were unable to do so at the legislature because the legislature, I would say it this way, their seeking of an amendment for the legislature suggests to me they believe that the Genetic Privacy Act does apply, otherwise they wouldn't go ask for this change. They didn't get confirmation of that from the legislature. When the 1 year the legislature adopted their proposed change, the governor vetoed it, expressing the view that it conflicted with the Genetic Privacy Act. So it seems to me all of this conduct, and we don't suggest that that's binding, but we do suggest that it means that you wouldn't give deference to the department's proposed interpretation of this statute that they propose to you now because it's not promulgated in the rule. It hasn't been accepted by the legislature, and in fact it was rejected by their superior, the governor, as being an improper interpretation.
Counsel, if we take the Genetic Privacy Act and just set it aside and just look at the newborn statute, can they do what they're doing now under that statute?
No.
I mean, you keep juxtaposing it to the GPA, but one fundamental question I have is, can they do what they're doing under the prior legislation?
No, it is our view that they cannot. The difference is this. Under the prior legislation, they can't do it because they're not authorized. Under the Genetic Privacy Act, they cannot do it because they're prohibited. One is the question of ultra vires conduct, going beyond the authority given them by the legislature. The other is actually violating a prohibition imposed by the legislature. Either way, and this maybe gets to one of the collateral issues about the 16 plaintiff children who were born after the passage of the Genetic Privacy Act. For the reasons just mentioned, they have a cause of action even if the Genetic Privacy Act didn't apply to the collection of their samples, to enjoin the Department of Health from exceeding their authority and using their blood samples in ways that are not authorized by the Newborn Screening Act. They also, of course, have a cause of action, we think, because of the threatened use of their blood samples, because any use of it, any testing for DNA, for example, that was done of a sample, even though it was taken prior to the passage of the Act and might not be subject, would be the collection of new genetic information and therefore would come within the Act. So in either way, we think they have a valid claim for an injunction. Somewhat of a collateral issue, but one that has been raised both by the Department and the Court of Appeals. The question then gets down to, I think, where the Court of Appeals seemed to come out was, well, you didn't bring any evidence that your blood samples of these 25 children have actually been used. And the Court of Appeals assumed that that was a disqualifying fact, and it is not, for several reasons. Number one, the Genetic Privacy Act independently prohibits the storage of blood samples, assuming it applies, and we think it does. It doesn't just prohibit the use, it prohibits the storage. And so even if these plaintiffs could not show that their samples were used, they have a cause of action to prohibit the storage of them. Secondly, the use is a fact issue. We're really in a catch-22 position here where the court said, I'm not going to allow you any more discovery, so you can't look behind the unilateral representations made by the department as to whether they've used these samples or not, but I'm going to hold you in a summary judgment standard to the obligation of having to bring forward substantial evidence that they're incorrect. Well, how could the plaintiffs? We don't have the information. It's all within the possession of the department. The department, in fact, could only confirm that it didn't use the samples for 23, or rather that it had records showing that it hadn't used the samples for 23. It could not make that statement for 2 of them for whatever reason, because no discovery was allowed to be done. This issue having the motion being brought 30 days after the action was started, we don't know the answer to that. Were records lost? Were these 2 used? In any event, the use is not an essential element of our claim. And then finally...
just because it's undisputed, is it that storage happened? I mean, is there...
I think that's right. I'll defer to counsel for the department, but there hasn't been any dispute
of them, but I just wanted to lay the template here. From your point of view, it appears to be undisputed that storage...
The other affidavits would suggest, Your Honor, that beginning in 1997 they began storing them. They do a refrigerated storage for a certain period of time, and then they move them off into room temperature storage. But they have, at the time of those affidavits, at least 800,000 of them, and by math they would have another 150,000 now. So I think there is no dispute. Getting back again to this question of use, also, even though it's not an essential element of our claim, when you look at the question of injunction, we wouldn't have to prove to get an injunction that they've actually used it. We asked them to be enjoined from their threatened use. They have already used 50,000 among the 800,000 of samples. There is no reason why they are storing these samples and resisting our attempt to get them enjoined from using them if they didn't intend to use them. Clearly there's a justiciable controversy that they threaten to use samples even if they haven't used them to date, sufficient to support an injunction. Why else are they holding them? They're holding them because they're a valuable resource if they are used. They don't have the authority to use them, and in fact it would violate the Genetic Privacy Act to do so. Maybe one final point to cover while my time is running out, and that is the suggestion made by them and by the Court of Appeals, well, you don't need this remedy because you can simply opt out of the Newborn Screening Act. It doesn't require that the department get your informed consent, but a parent can object, and you can ask that the samples be destroyed. So what's the harm? And the harm comes in several ways, and that opt-out remedy is not an adequate remedy at law and not one that should be imposed upon these plaintiffs. At the time that they were asked, not for consent, but at the time the samples were collected, several of them have said in affidavits they were not told about their ability to opt out. They were not then informed of it, certainly not adequately, not given any of the materials. So we have that fact issue. Now that they know that these are being stored, it would not be an adequate remedy for several reasons. Number one, it would require them to waive their rights under the Genetic Privacy Act. No reason why they should be required to do that. In effect, it would abrogate the Genetic Privacy Act. It would substitute the opt-out provision under the Newborn Screening Statute for what the legislature required as informed consent or an opt-in function of the Genetic Privacy Act, and its further effect would be that it would preclude judicial review of the conflict between these two statutes.
Counsel, in that regard, if you're saying under the Newborn Act they're not authorized to the use, storage, or dissemination through ignorance, lack of information, or whatever, what you're saying is that the damage that would result from an unauthorized use is so prevalent that the opt-out doesn't really protect from this unauthorized act. Is that the essence of it?
That's absolutely right, Your Honor. And if you look at Section 1308, which provides the remedies for a violation of the Genetic Privacy Act, it provides a combination of remedies. Enforce the act, seek an injunction, obtain damages. In other words, it doesn't provide exclusive remedies or suggest any legislative intent to restrict or limit the remedies, but it provides all remedies. And in fact, because this invasion of this privacy seems to be so sacrosanct, it provides for liquidated damages. You're not you're not required to show what your actual damages were to make a claim for damages. There is a liquidated damage provision that says from $1,000 to $15,000 per violation is appropriate under that statute. I see my time is up. Thank you.
Thank you, Counsel. You have 5 minutes for rebuttal. Ms. Olson.
May it please the Court. My name is Jocelyn Olson. I'm an Assistant Attorney General. I represent the respondent, State of Minnesota, the Department of Health, and the Commissioner of Health in this matter. The ultimate issue in this case is whether the newborn screening program violated Section 13386 by retaining and securely storing the test results and blood samples of these minor plaintiffs absent a receipt by the Department of a parental destruction request. The answer is no. The 2006 legislature enacted Chapter 253. In Chapter 253, you'll find both what has been called the Genetic Privacy Act, 13386, and also an amendment to the newborn screening statute, 144.128.5.
So let me ask you this question. What sense does it make to protect the information, the genetic information, and not protect the source of that information?
Your Honor, you're talking about the blood sample?
Yes.
That is a question for the legislature. There were certainly debates, I'm sure, as far as the Genetic Privacy Act goes, it was not debated in the legislature. It was adopted as a deleal amendment in 11:30 at night before the end of the legislative session. So that wasn't. But the legislature could say that genetic information includes the blood sample, but they did not. If you look at the definition itself, and I also would like to bring up to the Court that the genetic information statute definition comes directly out of the 2006 report to the legislature. In that report to the legislature, they suggested this exact definition, and they say that 1A was for, and this is in the record, by the way, the 2006 report, they said that subdivision 1A addresses when you get information from testing. So that's 1A. And then they said that's not the only way you can get genetic information. If your doctor interviews you or somebody interviews you and says, has anyone in your family ever had breast cancer? Has anyone in your family ever had high blood pressure? Has anyone in your family ever had a certain other diabetes, things that are heritable and everyone knows they're heritable? That is what is addressed in subdivision 1B. That is information collected from an individual about a genetic condition. 1A is talking about, Your Honor, Justice Gildea, right, you're talking about is collected from a sample. And the legislature could have put the sample as part of genetic information.
Counsel, I just want to talk common sense with you for a minute, if we could. And I'm looking at paragraph B.
Yes.
And just as a matter of common sense, to my mind, when my doctor asks me for a blood sample, and I give a blood sample because my doctor asks me for it, that's biological information collected from me. Now tell me why I'm wrong.
I think that the blood sample itself, if I would prick my finger here today, Your Honors, and show you my blood sample, you don't know anything about me from my blood sample.
Right, but the only reason the doctor's asking me for it, I mean, as the statute says, it might be used to provide medical care.
Correct.
Otherwise, the doctor wouldn't be asking me for it.
The information will be used to help you with your medical care. The actual
information collected from me. That's the blood sample that I just gave.
I would say that what gives information about you is the analysis of that. If you give the blood sample
But that isn't what subdivision B says. Subdivision B uses the word collected from. Subdivision A says analysis of. I mean, they're two different things.
I understand that, but my understanding of what the drafters of that language, which was in the 2006 report.
So it's your position that the statute's ambiguous then, and so we have to look to legislative history?
Yes, in that regard, I think so, because it is difficult to understand that. And I do think, and the department does protect the blood sample. They securely store that. What I want to bring your attention to is the two provisions in the 2006 law that were directly, one is about newborn screening and one is about genetic privacy. And in 144.288, subdivision 5, and I might have the right number wrong, but anyway, it says the department must destroy the blood sample within 45 days.
Counsel, I apologize, but I just want to go back to subdivision 1B and make sure that I'm understanding your argument. As I understand the exchange between you and the chief, you're saying that the words biological information collected is ambiguous because that could refer to a specimen or it could refer to the analysis collected from various sources. Is that what you're saying?
Yes, sir. Well, I think if I can...
I just want to make sure that I understand your argument so that my view in just first blush reading it was that it didn't include a blood sample. Then I listened to what your opponent argued, and the word collected kind of threw me because I think my blood sample is collected by my doctor, which I think is exactly what the chief was saying. So you're now saying that that language is ambiguous as to whether or not it includes a blood sample.
I think the blood sample itself has to be analyzed in order to get information. By itself, it's not information. It's something from which information is derived. It's
well, that's one interpretation.
Yes.
Is there also a reasonable, isn't it susceptible of the interpretation that the biological information collected would include a blood sample?
I rest my argument on the word information. A blood sample sitting on this table would not give you any information. You have to analyze it in order to get the information that's useful. There's potential genetic information on this desk because I touched it and left my fingerprints, but you're not going to be able, unless you dust this table, you're not going to get information about me unless you analyze that. So that is my rationale, and I would also refer the court to the 2006 report, which indicates that testing is not the only way we get genetic information.
Which gets back to my question. Why would you protect the information derived from the source and not protect the source?
I go back to that is a legislative prerogative. There are statutes that if it say genetic information is the biological sample and the information gathered from the biological sample, I think in order to read the biological sample into that definition, the court has to read language in.
It makes no sense to protect one without protecting the other, because it just makes no sense.
Well, and in that regard, I would say that the newborn screening law expressly provides differently than the Genetic Privacy Act. Those two laws, there's an exception in the Genetic Privacy Act for anything expressly provided by law, and that the legislature was putting the Genetic Privacy Act in place in order to cover situations that were currently not provided by law. The legislature there was a report of the legislature looking at all the laws that all the programs that might collect genetic information. One of those was the existing newborn screening program, and except for one thing, they didn't change. In 2006, they didn't change the opt-out provision. They didn't change the opt-out provision at all. And in 2006, the same year that the Genetic Privacy Act was enacted, they said that the department shall destroy blood samples and test results within 45 days of receiving a parental directive. That is in contrast with the Genetic Privacy Act, which says you can store information only so long as you have the written informed consent. So those two things absolutely don't match, because as counsel for appellant acknowledged, the blood sample is collected lawfully under the opt-out system. So we have the blood sample.
But counsel, it seems to me, I'm sorry, what's the point of retaining the samples?
The point of retaining the samples is the first thing is...
Once the heritable disease tests have been done, what's the point in retaining the samples?
There could be several reasons that could benefit the child directly. One would be that the test is done, and when the doctor looks at it or whatever, they have a question, and so they could go back to that sample and they could retest that sample to find out, like a second opinion. They could do a retest of that exact child. Another resource that could be right now there are 50-something tests. New tests are being determined. There have been actual cases, where a child was tested at a point where they only had, let's say they had 25 tests. Later that child developed some kind of condition, and they're able to go back to that blood sample and now do the higher number of screenings on it, and they could discover something directly applicable to that child. So that is...
Counsel, let me take you a different direction. I'm concerned, I guess I'm very interested in your response to what I call the subdivision 3 argument, which is, unless otherwise expressly provided by law, the only thing that the commissioner can do is collect the information. They can't use it without informed consent, can't store it, can't disseminate it. And as I understand their argument, there's nothing in Minstat 144-125 subdivision 3 or the commissioner's duties that gives the commissioner the authority to use, store, or disseminate. How do you get around that?
The 144.128 subdivision 5 specifically says that the commissioner shall destroy the blood sample and test results within 45 days of receipt of a parental request. It makes absolutely no sense to say that the commissioner, that's current law.
Okay, well, let me just stop you there. That seems like that's implied authority, but not express. And as I read subdivision 3, it says, unless expressly provided by law. Where in the statute, 144-125, does it expressly give the commissioner the authority to use, store, and disseminate this information?
The 144.128.5, the only way you can read it, you can't destroy it unless you have the ability to retain it. So I think that's express authority to retain it, or at least a clarification that acknowledgement by the legislature that they knew that the agency was retaining this information, and is expressly putting a limit on that now and say...
Even if you're right about the storage issue, which I think may be a separate problem, maybe we'll discuss that with opposing counsel. But what about the dissemination piece? You don't even have a negative implication argument there. Where's the authority, express or otherwise, to disseminate?
Your Honor, there is no dissemination in this case. So anything that I will say about this, I would consider it a hypothetical, because
There's no question that dissemination has occurred, right? That's a fact that has been the result of discovery, but it may not affect these parties. Am I right about that?
There has been no dissemination of these parties on the record that we have here.
Anyway, how do you deal with the dissemination issue?
At the trial court, they do not have a cause of action for dissemination because there was no dissemination. So it's a hypothetical point. However,
Counsel, I thought that there was a discovery issue there. They haven't had the opportunity to conduct discovery on that issue.
I would actually disagree with that, Your Honor. The court set an October 16th discovery deadline, the district court did, and the state produced, at least given the numbers that they've sent briefs, the state produced about 8,000 pages of documents. We answered interrogatories. We also answered requests for admissions. And during that whole summer of 2009, there were no depositions noticed by the. So if they didn't do discovery, it was their choice not to do discovery. They did not ask the district court for an extension of the discovery deadline. They did not make a motion under 56.06 for specific discovery in order to.
Well, maybe let's go back to the dissemination point, and perhaps it's dicta, and perhaps it's there's some other argument about it. But how would you respond to the argument about dissemination?
I would respond to that by saying that under the definition of genetic information, it has to be about if it's a blood sample, which is mentioned in 1A, and if you're calling that a genetic information for the purposes of argument, it has to be about an identified individual. The department, when it does research with outside entities, there are a number of restrictions on that, and one of them is a blood sample is either totally de-identified, which is the vast majority of research, and that is consistent with research all over the country, that the blood samples are de-identified, and therefore, under the very definition of genetic information, when the blood sample is involved, it doesn't identify a person. So it goes to the researcher. The researcher's getting whatever test results they're doing are de-identified. There's not information about an identified individual. And to the extent under B that they're not getting information for the purposes of treating that child, it's for scientific research purposes. So that is how.
Of course, the de-identification doesn't work very well if that information is run through a database containing DNA, does it?
Your Honor, I understand that if you have a DNA profile of a person, it doesn't actually identify them until you have another match.
Exactly.
But
so I just want to understand your argument about the department's authority to use the samples. Let's put aside the question of retain. So what limits, if any, are there on the department's authority to use the samples? You're saying if they are de-identified, the samples are just like Just materials? They can be sold?
No, Your Honor, the department does not sell that, and the plaintiffs' appellants have been trying to suggest that it's marketable and that we're selling it. It's done, it's used, it's only disseminated when the department co-partners with research organizations to, for example, and most importantly, to find new tests for newborn screening. And they have to go through their institutional review boards.
Let me just ask you generally, what under your definition, where do we find the limits of the commissioner's authority to use these samples?
The commissioner's authority to conduct tests and studies is in 144.05, and I think it's per NA. It's mentioned in the brief. The department has the authority to do studies, and then when they do studies, they either get with outside groups, that they are basically partnering with these outside groups, and they follow all of the regulations that have been produced to protect human subjects. It's not like the department just puts them out there and says, would anyone like to have some baby blood samples? It's not like that. It's done for newborn screening purposes to find new.
I know you're telling me how it's done. I'm just saying, what are the limits of the authority? If and you're saying the authority, as long as we're doing testing.
Any time they are doing testing, I think it's in a way it's a moot point, because I think that the way the testing is, or the way if samples are shared with an outside researcher, it's completely in harmony with the Genetic Privacy Act, in the sense that if it's identifiable information, they go directly and get written informed consent. That is the practice. So that is what's called for in the Genetic Privacy Act. So whether you're saying you're complying with it or you're not complying with it, it's consistent with it. And then it's also consistent with it as long as you de-identify the data, that researchers are not getting information about that individual. They are getting scientific information. And as far as that, I guess.
Counsel, I can understand your argument. You're saying that you're using it properly, using it for good purposes, but my concern is whether you're authorized to do that. Because what we're concerned about here is the misuse of this information, and that's when the real collateral consequences happen to real human beings. And so I want to focus on your argument about you saying is that under the Newborn Screening Act, there is express authority to store, use, and disseminate. And I'll focus on the most specific one where it appears to be no question that there's storage that's happening. Now, express is a pretty strong word. It means specific, definite, clear. I mean, go any place is unmistakably communicated. And you say that, I'm looking at 144, 128, we get there because of, is it subdivision 5? Is it that you can request that it be destroyed and it has to be destroyed within 45 days? That means that line there, the fact that you can request it destroyed, is the authorization line for what you're doing?
I think you have to read that language also in connection with 144.125, subdivision 3, which instructs responsible parties. It's the responsible parties who collect the blood sample and have the actual physical interaction or, communication with the parent. And that responsible party is instructed to inform the parent that the blood sample and the test results may be retained and the benefit of retaining those things. And it would be an absurd, we talked in the last case about absurd result. It would be an absurd result for this court to hold that, yes, a hospital has to inform a parent that these things may be retained.
Counsel, you're using the term as that inform that it may be retained. And in fact, there is authorization to retain positive results. Is that correct?
It is, but
so how do you get from I think that's an accurate instruction given the law and the authorization. There's authorization to retain positive results, but how do you get it may be retained, and it may be retained. If it may be retained as a positive, how do you get that to expressly expand to the ability to retain all samples?
I'm going back to what I believe is the legislative intent here, because the legislature knew that the Department of Health was retaining samples. In 2006, they adopted amendment to the Newborn Screening Act, and they adopted the GPA. And if the GPA was supposed to govern the retention of samples, why didn't the legislature redo the Newborn Screening Act in a way to instead, they kept the opt-out.
Let me ask you an additional question that's based on what Justice Anderson is saying. Not only is there authorization to retain for positive results, but presumably there's authorization to retain while you're actually doing the testing itself, right? So subsection 5 or part 5 here could be referring either to the positive test or for whatever period of time it takes to actually do the test. To me, that doesn't give you independent authorization to hold it indefinitely. Am I missing something?
Well, I believe that the legislature intend this matter to be an opt-out system, and that retention is intended to be allowed. I mean, the point that hasn't come...
Counsel, I know your time is running out. You've answered both questions, mine and Justice Strauss, with the statement, I believe this is the intent of the legislature. We need more than that. So give me your best shot as to that the retention is specifically or expressly authorized, other than your belief. And I see now you base it on two things, and anything more than the 45-day opt-out and the responsible parties notice.
That's what is in the statute as far as specific to the newborn screening statute. Those are the two. Your Honor.
Thank you, Chief Justice. You were starting on a point about what you thought that this would produce an absurd result, and you were interrupted and weren't given a chance to finish. Could you finish that point that you were making about where you think there might be an absurd result here?
Yes. The legislature has unambiguously required hospitals and physicians and people who are at the scene of newborn screening to inform parents that test results and blood samples may be retained, and to explain to them the benefits of retaining them. So if the court should hold that the department has no authority to retain them, then that it's absurd to require, it would be a violation of the statute for the hospital not to tell the parent that these may be retained, and the statute that they may be retained is not limited to positive or negative results. So negative results can also be used as normal, or what do we call that, when you do research. Thank you, Your Honor.
Thank you, counsel. Mr. Hanson, you have 5 minutes for rebuttal.
Thank you, Your Honor. On the question of express authority, it seems to me that the reliance by the department on the notice given to parents that they may retain is as far away from express as you could get. At most, it would create a negative inference that the commissioner may retain. Retain for what purpose? As your questions have indicated, it might be retained for the 2 weeks to get the testing done. Some of it sent down to the Mayo Clinic as a subcontractor. It might be to retain the positive test results. That simply doesn't mean express. Now, the suggestion is made that the term express may provide otherwise is ambiguous, and you should look to legislative history. We think it's not. It's a very common term used in legal jargon all the time. But let's look a little bit about what happened here. The ALJ in 2006 said the Newborn Screening Act did not expressly provide. It went up to the chief ALJ. He likewise said these provisions that she's just argued about are at best implied. They certainly don't need express. What happened then? What did the legislature do? The department went at least 3 times, 2007, 8, and 9, to the legislature, now facing this ALJ decision that they were subject to the Genetic Privacy Act, and asked for exemption. The Genetic Privacy Act be amended to exempt newborn screening. The legislature did not. Does that suggest the legislature meant in 2006 to exempt newborn screening? When given 3 opportunities to do it, they declined. Now, they did agree once, and then the governor vetoed, because he said, it's clear to me, the Genetic Privacy Act applies, and this language in this bill would exempt you, and we don't think that's appropriate. So what do we take from that to be the legislature's intent? In 2006, when they passed the Genetic Privacy Act, they did make some amendments to the Newborn Screening Act. But
wait, I'm going to pause here. You asked the question, what do we take from that being the legislature? We just don't know, do we?
At the very least, there's a negative inference. If they intended back in 2006 to exempt, why wouldn't they pass this bill to exempt first 3 times? Maybe they have it in front of them right now. I don't know if it's still pending. But she argues that in 2006 they made these other changes to the Newborn Screening Act, which wouldn't be consistent with it being subject to the Genetic Privacy Act. But I think it is totally consistent. To say that you must destroy a sample if requested isn't contradictory to the requirements of the Genetic Privacy Act that prohibit you from getting the sample or using it or storing it without informed consent. It's complementary. If you got informed consent on the front end, the parent could still later come back and say, I've changed my mind, I want to have that sample destroyed. And so having a provision that authorized the commissioner to destroy the sample on a parental consent doesn't suggest anything contradictory. It's complementary. The question of de-identified use of the information as a solution to this problem gets you nowhere, because the Genetic Privacy Act says very clearly, if you want to store it, if you want to use it, if you want to disseminate it, what you have to do is get the informed, affirmative consent of the parents. Not this negative inference, failure to object, but the positive informed consent. It doesn't write in an exception to say, but you don't need informed consent if you de-identify the information. That's not in the statute, and so that is not a solution. But back to the question, I think Justice Page asked, how do you de-identify a blood sample? What is more identifying of a person than your DNA? It tells you more than your address. It tells you more than your parents' names. It tells you more than your Social Security number, even. It tells you the blueprint of your physical being. And so de-identifying might have been an administrative action taken to minimize their violation of the Genetic Privacy Act, but it still is a violation and it doesn't solve that. If there are no further questions, thank you for your attention.
Thank you, counsel. Thanks to both counsel for your help in this case. This matter is submitted.